My name is Kate Colleary and I run a boutique legal practice specialising in data protection and freedom of information and intellectual property law. So what I've been doing over the past 6 months is working with IFA to try and minimise the number of issues that may arise for you, IFA's members. So I'm looking at data protection and trying to guess what the issues will be for you. And I think we've got a draft protocol in place and we have some agreements in place that Rebecca has alluded to, and hopefully we will have dealt with all of those. So to give you some background as to the data protection considerations that I've been thinking about, I'm going to run through those considerations. We'll have a look at some member responsibilities. So as companies who are members of IFA, what are your responsibilities in terms of data protection when it comes to uploading the transfers of value data? Is your company a data controller? Well, yes, it is. And if so, what are your obligations? And that feeds into the previous point. We're going to look at contracts and consent, and they are the two bases on which we are relying to upload this data so that you're compliant with data protection law. And we're going to go through those in a bit more detail. And then, as Rebecca said, sometimes the data is going to have to be amended. It may be amended because consent is revoked. It may be amended because there's an error. So how do we deal with that, and what is the protocol around amending that data, and who's responsible for it under the Acts? And then finally, we're going to look at the implications for breaches of the Data Protection Acts, which I hope won't happen because you'll all be well aware of the issues well in advance of uploading any data. So when you're uploading the information relating to the transfers of value data, some of that data could constitute personal data. And if it constitutes personal data, there are certain obligations under the Data Protection Acts. And they're what's going to give rise to data protection concerns. So what is personal data then? Well, under the Data Protection Acts, personal data is any data relating to a living individual, and that's key when we're looking at this type of information. And it's a living individual who can be identified either from the data set itself or from that data when read in conjunction with other information held by the data controller. But key there is living individual. So the Data Protection Acts will only apply to the individual consultants, the individual medical practitioners that you're dealing with. They don't deal with transfers. It doesn't relate to transfers of value, say, to Blackrock Clinic, to Beaumont, or to whatever other legal or whatever other medical organisation you might be transferring data to. It's only when it's relating to the living individuals. So it'll apply in practical terms. It's going to apply to consultants. Sorry, I have a question down here.
This in a number of other countries. How are you handling, or how is IFA handling single director companies where the name of the single director, John Smith Consulting, if you like, as a HCO, but it's the name of the physician?
I mean, best practice would be, and we're going to come through how we're going to operate the system, what we've recommended is actually that you're going to have the same rules in place for both individuals and for the healthcare organisations, so that you're going to try and get consent to that data being disclosed, whether it's a mere director of a company or whether it's the person operating in their personal capacity. Technically, under the Data Protection Acts, if a director is merely acting in furtherance of his obligation as a director, well, that isn't inherently personal data under the Acts, and that would be the view of the Data Protection Commissioner. But belt and braces approach, I think, is appropriate here. So we're going to try and achieve consent across the board from any individuals whose data is going to be uploaded. I think that's the in terms of mitigating risk, that's the most appropriate method. But of course, I mean, there are always going to be individual questions. So please do feel free, if issues arise, to give me a call, to give Rebecca a call. We've been fielding questions and answering questions over the past 6 months as this process has evolved. So hopefully there's little that we haven't seen already. So please do feel free to get in contact. So we have the data, we've uploaded it. But by uploading it, that means you're processing it. So if you've got somebody's personal data and you're making it available on a publicly available website, you're processing that data under the Acts. And there are certain obligations under the Data Protection Acts that you are going to have to comply with. So what are those obligations, and how can we legitimise what we're doing? How can we say, it's okay for us to upload this data because we've done the following? And we've looked at that here. We've said the obligations are firstly, it's security. Most of you, anybody here in the IT department of your organisation will be well aware of the concerns around security, particularly at the moment. So there are obligations under the Data Protection Acts relating to security when it concerns personal data. Transparency, that's the whole initiative really, but the transparency initiative doesn't just relate to letting the public know what transfers of value are being made to consultants. It also is about being transparent to your consultants as to what you're doing with their data, with their personal data. And then also the consultants are going to have access and amendment rights. So if something is incorrect, is no longer relevant or is misleading, they can ask you to change it. And then finally, there are these obligations. How can you process their personal data? What allows you to process individuals' personal data? And we've looked at this and we've sought two justifications. There's a whole list of them under the Data Protection Acts, and you can rely on a number of them from, maybe giving data to, in terms of legal proceedings or in criminal investigations, and they're not relevant. So the two that we have relied upon for the members of IFA are, one, that the data subject has consented to the data being processed in the manner in which you're going to process it by uploading it, and two, that the data is being processed for the performance of a contract. And that covers those circumstances where the data subject, the consultant, has entered into a legally binding agreement with you whereby they are given, whether it's money for clinical trials or whether they are flown off somewhere and their hotel accommodation is covered, that is subject to contract. And in that contract it says that in return for us providing this to you, you are allowing